the plea on Taj Mahal has been rejected. The Allahabad High Court has rejected a plea for the survey of Taj Mahal. Leave the truth of Taj Mahal to historians, says the Allahabad High Court, very, very clearly rejecting a plea of the petitioner, saying open the 22, open the locks and let us examine the 22 rooms in the basement of the historic Taj Mahal. There was a prayer. The High Court has said the plea to constitute a fact-finding committee to find out the real truth behind Taj Mahal is non-justifiable action. The High Court has said this cannot be adjudicated upon by this court. The High Court has also said for the prayer regarding opening of the rooms, historical research ought to involve proper methodology and should be left to historians. It's a huge setback to the petitioner who claimed that the Taj Mahal was actually Taj Mahal or an ancient Shiv temple. The High Court refuses to entertain that plea where the petitioner wanted 22 rooms inside the Taj Mahal that were locked. There you see that image of that lock on India Today. He wanted this lock to be opened, the 22 room survey claiming there was a temple underneath. That prayer has been dismissed. The Honorable High Court has said, leave the Taj Mahal study to historians. Not just that, the court was scathing in its indictment when the court said, let the petitioner do proper research, enroll in a university, do a master's degree, pursue a master's degree, then do a PhD, and then in case there's a hindrance, approach the court once again, clearly indicating that this was a frivolous petition. I quickly want to cut across to India Today's Aishwarya Paliwal joining us with the latest. Aishwarya, bring us the latest. What did the court say?
Well, Gaurav, let me tell you, the court very clearly said that this is not something that they can look into. Whether there is something in these 22 rooms is something that needs to be discussed and that needs to come to the fore from the historians, and this is not something which comes under the purview of court. Very clearly, they are saying that the petition has been dismissed. They do not want to talk more about it, and this was, Gaurav, also very clear from the fact the kind of statement that the court has made, that when now you are trying to enter these 22 rooms, tomorrow you will want to come into our chambers and see what's inside. So we could see for the past 2 hours at least the kind of meaning that the court had, and now they are saying whether there is something in these 22 rooms is something for the historians to decide. It is not something that the court can take a call on. Gaurav.
Very, very clearly, Aishwarya, the court saying, go do your PhD. And PIL, Aishwarya, a public interest litigation is meant for very serious issues. A public interest litigation cannot be used for frivolous issues. And this, apparently, in the court verdict, they found this issue to be extremely frivolous, Aishwarya.
Exactly, and this is what the court said, Gaurav, that you're trying to make fun of PILs, and this is not something which should come under the purview of PILs. This also, Gaurav, from what I personally understand, that the court is trying to send a signal to all those people. We see some of the people who regularly go to the court to fight PILs. The court is also telling them in a veiled attack that don't make fun of PILs, don't come up with such topics, because this is something which, to be honest, Gaurav, is something that the historians should be talking about. Court has also very clearly said this is not something that the court can take a call on. Leave it to the historians, but also in a very stern way telling the petitioners that today you want to make sure that these doors are opened. Tomorrow, who's stopping you from filing a PIL or others from filing a PIL, and then saying they want to enter a judge's chamber and see what things happen behind closed doors. Gaurav.
Aishwarya, this is Nabila here. We're looking at the court now striking down the plea, but this is not the first time a demand of such nature has been made. In fact, Taj Mahal, this is what many of the Hindu groups claim, that that stood even before Taj Mahal was made. It was destroyed by the Mughals until they erected this monument over a temple shrine. That's been the appeal of the Hindu groups to, in fact, survey into the Taj Mahal, try and open up at least 22 doors that have been locked. because there could be some secrets hiding behind some relics that could be placed inside those closed doors, which the Hindu groups demand to be exposed and revealed. At a time when we're looking at the Gyanvapi mosque hearing taken up by the Varanasi court and asking for a survey into this, there was much expectation undoubtedly by those who filed a plea on the Taj Mahal as well. How are they receiving this verdict?
Well, from what I can gather and from what we can understand, the way in which the court has handled the matter, this also will be something which will prevent others from coming up with such pleas. We are seeing PIL after PIL being filed, and as with regards to Taj Mahal, opening these doors, and the claim, however, is that this is not a monument. This, in fact, used to be Lord Shiva's what people are saying is that if you break the Taj Mahal, if you start digging, if you open the doors, you will find a temple. So all these things, without any historical facts, is something also that the court observed, said that these things cannot be looked at from the court's purview. This is something which historians have to take a call on. So definitely we are seeing the court giving very clear instructions, and this also will. I think that's what the court is trying to make sure, that other people do not start filing these PILs, because then we will open a box, and many other monuments, all the other monuments in fact in the country, everyone will then come up with a PIL, and the renaming and the opening of closed doors will begin. Nabila.
Well, it's very interesting to note that this monument Wapsi debate that rages on one hand, you had the Gyanvapi mosque and the hearing that was taken up at the Varanasi court, which upheld the plea asking for a survey into the Gyanvapi mosque to see if there was any Hindu religious significance within that mosque. That on one hand. On the other hand, you had plea asking for 22 doors of the Taj Mahal to be opened up, citing that there could be Hindu relics placed inside those closed doors which needed to be exposed. On one hand, you had the Varanasi court saying that yes, a survey will be carried out into the Gyanvapi mosque and to check if there is Hindu significance. On the other hand, you have the Allahabad High Court who's striking down the plea made to ask for those Taj Mahal's doors to be opened up, citing that there could be Hindu religious significance. Two courts in Uttar Pradesh simultaneously now, one upholding the Hindu group's plea at the Gyanvapi mosque and one striking down, the Allahabad court striking down a plea asking for Taj Mahal to be opened up, citing the same reason, that there could be Hindu religious significance. In fact, Gaurav joining me on that. Gaurav, this is more or less how you foresaw, you did foresee the situation unfolding the way it did. In fact, we see that Gyanvapi mosque is a mosque that has a great religious significance with the Hindus, and this is a known fact. It cannot be taken away from the Hindus undoubtedly, because the mosque was indeed built aligned with a Hindu temple there. Some say the Hindu temple was completely crushed to build a mosque. Well, that said, you have growing demands that's coming to fore now on the Taj Mahal as well, on similar demands that this was also built over a Hindu shrine. Many of them saying that there was a Hindu palace that was desecrated and a Taj Mahal was erected. Now, with one court upholding the Hindu group's plea, the other court striking it down, how do you look at this situation today for the Hindu community at large?
So the learned judges in both instances have decided cases on the merit in their petitions so far. As far as the Allahabad High Court verdict is concerned, the Allahabad High Court is very clear that a public interest litigation should not be used in such a frivolous manner. And they were scathing in their indictment of the petitioner when they said that as far as education is concerned, leave it to historians. As far as facts are concerned, leave it to historians to use proper methodology to come to a conclusion. It cannot be a court-ordered opening of 22, rooms inside the historic Taj Mahal. They said, go do your MA, go do your PhD, learn facts, and then come. They also were extremely clear that in this case, as far as the Taj Mahal was concerned, it should not be made into, what the petitioner wanted, a court-monitored investigation into whether there was a temple there earlier or not, or as, Member of Parliament of the Bharatiya Janata Party, Diya Kumari of the erstwhile royal family of Rajasthan, of Jaipur, had contended that this used to be their area, and so on. So the court has dismissed this case. As far as the Gyanvapi mosque videography is concerned, there is a petition that seeks right to pray at a place of religious worship. They have made certain contentions. Now, based on facts, court moves on facts. Court moves on evidence that's produced in front of them, and that videography will produce evidence if it exists. Because, the Hindu side may have a point of view, the Muslim side will have a point of view. Based on facts, the courts will take a decision. As far as the apprehension that situation could spiral out of control is concerned, it's for the Yogi Adityanath administration to ensure rule of law prevails, come what may.
Right. Gaurav, I'd really like to come back to you on the stark difference between the two pleas here, one for Taj Mahal and one for Gyan Vapsi. Both Hindu groups appealing for the same, that there is religious significance at these places. It needs to be explored. I'm going to come back to you on that, but before that, Aishwarya, who's been tracking the court developments there, Aishwarya, we see that the Allahabad High Court, while striking down the pleas asking for 22 doors of the Taj Mahal to be opened up, says leave this matter to historians. We see in the Gyan Vapi mosque case, the Muslim community managing that mosque is now appealing to the higher court. Will the same Hindu group who's appealed for Taj Mahal's doors to be opened up appeal to a higher court in this case?
Well, we'll have to wait and watch whether that happens or not. But from what we can understand at the moment, as far as the Taj Mahal case is concerned, the court is very clear. And in fact, the petition has been dismissed. So this also paves the way if any other people or if the same group wants to come with the same appeal. Again, we don't think the court will take it very lightly. The court, in fact, has very clearly said what you are trying to do is something which does not come under the purview of the court. So it does not look like if other people also go to the court will change what they feel. They are also saying, one thing which came out from the court, which is very, very important. Before they said that we will not look into it, they very clearly said you cannot open this door, because once you say that open all the 22 doors inside the Taj Mahal, you will then turn around and say that you want to enter our chamber. So now this was a very personal example which the court gave, which clearly talks about the fact that these kind of things were history. If we talk about that, if those are the things which the court does not want to get into, and that is precisely the reason why we are seeing the petition being dismissed.